There are some things that can get in the way of our ability get in the way of our parties' ability to have mutual assent. One of these things is undue influence or duress. And the other thing is that all parties need to have legal capacity without mistake or fraud, misrepresentation, or omission. So we're going to talk about now what each of these terms means. We're going to do a little more like Inception, where we go inside each idea and then we drop inside another idea inside the idea. Hopefully this will make more sense than that did. So we call this reality of consent. Achieving reality of consent is when we don't have these impediments to our mutual assent. And we're starting out by conjuring up the story of Romeo and Juliet. Romeo is killing himself. Why? He is over here operating under one heck of a mistake of fact. Romeo thinks she's dead. In fact, she's just seeming dead. And if he'd gotten the message in time, he wouldn't be killing himself. But when we make decisions under a mistake of fact, which is a misunderstanding of one or more material terms, we may act without true mutual assent. We thought we were in the same pact, and it turns out we actually had two different contracts going on here. The buyer thought they were buying residential, and the seller thought they were selling commercial. Nobody knew there was this fundamental misunderstanding. When we have a mistake of fact like that, that is an excellent reason for somebody to get sued. If it's a mutual mistake of fact, and it's not the result of fraud or negligence, then this may be a reason to rescind the contract or to cancel the contract. If the buyer thought that they were buying residential and the seller thought that they were selling residential, and then the seller realizes this property's been rezoned for commercial, they would rather sell it for commercial prices. And the buyer's like, well, crap, I can't buy a commercial property. They won't give me a loan on that. In that case, you've got a great reason to cancel the contract. Put everybody back in their original positions, go on your way. It's also possible to have a mistake of law. A mistake of law is a failure to correctly interpret or complete a contract. A mistake of law is not an excuse for getting out of the contract. You still got to complete the contract. It's a shame you didn't understand how it was supposed to be completed. It's a shame that you didn't know what you were supposed to do. Just because your agent lets you do something foolish does not mean you're out of your contract. It just means it's an excellent reason to sue your agent for letting you do something foolish. This is why it's imperative that we recommend our clients seek legal counsel before signing a contract. That's a legal document. Legal documents require legal interpretation. They should have their attorney review this with them. Buyers have attorneys. They have to here. So find out how much does it cost for this attorney to provide that buyer that service of reviewing the contract. And then make sure we review contracts with them before we make an offer. Because at the time of offer, that attorney is not trying to go over a contract with your buyer at 8 o'clock at night. Fraud is the next thing. Fraud will create not a void contract, but a voidable contract. A voidable contract means it is the party's discretion to determine at the point that they realize fraud has been committed, if they want to go forward and validate the contract, or if they want to get out of the contract and declare it void. Okay? If they decide to go forward with the contract, they still have the rights to pursue that this was fraud and to pursue judgment for the fraud. Okay, there is the Unfair and Deceptive Trade Practices Act that governs fraud and will hit you with 3 times the damages if they can prove it's fraud. But there's only one way, there's only one little problem here with fraud, and that's you have to prove all 4 elements of fraud in order for it to be fraud. You have to prove that there was a misrepresentation or omission of a material fact, that there was a knowledge of its falsity and a reckless disregard for the truth, that this misrepresentation or omission was intended to be acted on, that the person did act upon it to their injury. What is the level of disclosure sellers are held to? Avoid fraud. That's all sellers have to do in North Carolina. Avoid fraud. These 4 things have to be proven if you're going to hold a seller's feet to the fire for not giving you the correct information in North Carolina. You have to prove the seller knew that what they were saying was not correct, or what they were leaving out was absolutely necessary to be known. You have to prove that they had a reckless disregard for the truth, that they knew it would cause them harm if they acted on it, and that they intended for it to cause them harm, and that they did act on it, and that it did cause them harm. If you can't prove all 4 of these things in a court of law, you can't hold the seller responsible. Innocent misrepresentations are also impediments to mutual assent. That's when you say something and you didn't know it was wrong. You made a terrible mistake. This might be a reason for everybody to get out of the contract, and it might be a reason not to. Innocent misrepresentations, you get the slap on the wrist. But if they can prove that you as a real estate broker were out there intentionally misrepresenting things with the intention to cause harm, and that it does cause harm, well then, you're not only in trouble in court for what you did under license law, you're also in trouble in court under the Unfair and Deceptive Trade Practices Act, another federal law that is going to grant 3 times the damages if you make misleading advertisements, or you provide misleading opinions or false inducements, if you withhold material facts, or if you make misrepresentations, including guarantees and warranties. If you do these things and they can prove you did them with reckless disregard for the truth, knowing that it could cause harm, intending them to act upon it, and then it does cause them harm when they act upon it, can you be held responsible here? Yeah. If you're a broker, and even if you're just an owner who regularly sells real estate. If the for sale by owner down the road, however, wants to go out and sell property and commit fraud, they're still not held under this. They're held in trouble for fraud, but not 3 times the damage. So the seller, you got to prove fraud. And then all you might get out of them is the money that they owe. Don't expect pain and suffering. If it's a flipper or a real estate broker, though, get ready. We can bleed them dry. Oh, wait, we're them. Oh, crap. Duress. Another impediment to mutual assent is duress. That sensation that you are being forced to contract under some kind of threat. Duress is voidable in a courtroom. You're going to have to prove that there was a threat, because nobody's going to just say, okay, I was threatening you. If they were, that's not a contract they're going to keep you in. So we want to be very careful in 2 ways when it comes to duress. We never want to give a client a reason to claim duress against us. If you don't buy this house today, you'll regret it for the rest of your life. Put $100,000 down or don't even bother. I'm just saying, the market is hot. If you don't go in over asking by at least 20,000, you're not going to win. How many statements like that can I make to somebody before they get the impression that they're under threat? You've got to be very careful as you underscore how powerful the market is, that you do not make that client feel like they are under threat, because they can claim duress and they can claim it against you. Or they might claim undue influence. Undue influence is when a fiduciary uses their influence for personal gain. It's also influencing a legally incompetent party in a transaction. Now, influencing a legally incompetent party in a transaction is when we're over there helping Kanye and he's off his meds. And we knew he was off his meds because he was like, meds are for suckers. And we just kept on showing him the biggest private islands we knew he could afford. Using our influence for personal gain could very easily be misconstrued when I say you got to make an offer over asking. Because what do I get when you make a bigger offer?
A bigger check.
Exactly. It is very important that they understand it's the market that drives your advice, not your personal interest. And that's why you've got to do your CMA. Your comparative market analysis is your vital proof in what the property can ultimately appraise for, and this is why we're making our offer. If you're not doing that CMA in order to suggest the offer price, then you're opening yourself up for all kinds of potential threats and litigation. It doesn't matter if they want to offer over that. You need to make sure that you present what you believe it will appraise for. And make sure they have a conversation with their lender about what happens if they go over the appraised value. Because if they cannot afford to make up the difference, if their loan product will disappear because of that gap, then it doesn't do us any good to win the contract. if we can't close it. It just puts our client in a terrible position to lose their due diligence. Even though you're over there fully justified in the advice you're giving, you need to be balancing the advice on how offers are being made with the advice of how likely they are to survive through this process. The other issue you got to be aware of is that it's not you, it's the parties to the contract themselves who may be putting each other in these positions. You want to be alert to situations where you feel one party to the contract doesn't really want to be in it, or doesn't really have the capacity to be in it. Okay, if you are in there and it's Granny's house and their nephew is helping Granny sell it, and you feel like Granny doesn't have all of her marbles, then you may stand on the chopping block beside the nephew for influencing a legally incompetent party in a transaction, if only to give up your compensation. And a deal where my compensation doesn't stay my compensation is a bad deal. Let's go look at the activity from the manual that the commission has asked us to include, and I want you to tell me what we are going to sue for here. A listing broker tells an interested buyer that the developer is working with the county to pave the gravel road leading into the subdivision. I'll do it in a British accent, so it sounds fancy. In fact, the developer never intended to pave the road, never contacted the county, and refused to pave it. The listing broker did not make this representation to other lot purchasers who didn't ask about the road. If the broker's misrepresentation induced this buyer to purchase the lot, the buyer may bring an action for damages because the lot is worth less with a gravel road than with a paved road. The buyer may also be able to rescind this contract. The purchasers of other lots do not have a right to sue for what? Because no assertions about the road were made to them. What does this buyer have the right to sue for? Fraudulent misrepresentation. That's not just the difference of the paved road, that's 3 times the difference between the value.
So who pays the damages? Does the broker pay the damages?
Yeah, because we can't. Yeah, because the seller didn't do it. It was the broker that did it. Moving on. So we know the essential elements to a contract are basic. It is going to be if we have 2 parties who are in their right minds, who intend to get into a contract, who have something of value on the line, and there's a lawful objective. That's the basic definition for all contracts across all contract law. But other laws come in and lay down additional requirements depending on what kind of contract it is. Does anybody know what we call the law that requires the contract to be in writing?
Statute of frauds.
Statute of frauds. That's exactly right. And I have the Statue of Liberty here because I remember the Statute of Frauds as a statue of abroad. So statute of frauds, statute of frauds, right? Because, yeah, right. And she's got a book and everything. So which kinds of contracts have to go into the statute of abroad's book? How about any contract that's going to convey an interest in real property is going to have to be in writing from the beginning. Now, what we say in pre-licensing is that, and then we stop. But the truth is, it's not just in writing. It's got to be in writing with the names of the parties, with the subject matter of the contract, with the material terms and conditions, material terms being the terms that would rise to the level of a breach if they're not met. Signatures of the parties. This is what stops lots of things from qualifying as meeting the requirements of statute of frauds. It doesn't have the signatures of the parties. Why can't I just send an email to somebody else and create a binding contract between us in real estate? Because the signature of the parties. The only way to do that in an email is to tell somebody, if you sign this, then that'll make that a binding signature, right? Like DocuSign does. If I write that out in an email, do you think somebody might want to accuse me of illegal practice of law? It sure does sound like I'm trying to write something legal, doesn't it? Yeah. So I don't ever want to try to form a contract via email, not for real property, certainly not for pieces of real property. So when we talk about a contract to convey an interest in real property, what do we mean by that? Could be ownership, but it could also be options, right? It could be installment land contracts. It could be mortgages. An interest in real property means a legal right. So, and convey means transfer. So anytime we want to transfer a legal right in real property, it's going to have to meet the requirements of statute of frauds, because these are things that we're trying to pass an interest to that property, whether it's an interest to the deed if I don't pay my bills, or an interest to possession, or an interest of defeasibility and ownership. Do leasing contracts count? There is an allowance, so 3 years and under, to be oral and still fully enforceable in a court. Why 3 years? Does anybody know at what number of years most commercial contracts start or will not start, but less than? No less than 3-year terms. Very rarely will a residential rental agreement start that way. So the idea here is, if you have a handshake deal with somebody in a residential rental, you still have a valid contract in the eyes of the law, whether or not it meets the requirements of statute of frauds. However, if you are a commercial renter, then you ought to know better. You ought to have knowledge of what you're doing. If you get into a handshake deal with somebody for more than 3 years, then you're standing on your own reconnaissance over there, you silly. Now, how can we sign it? Show up at their house and have them give me a wet signature, which sounds disgusting. But really, it just means it was done with a pen. We only have one set of documents left that need a wet signature. Do you know what those documents are? How about the ones with at the settlement table?
Yeah.
Thus far, we
yeah.
have not been able to avoid going to the settlement table. We, even during COVID, we had to roll down our car windows, remember, and sign papers. We cannot transfer our settlement documents electronically yet, I don't think. We might have finally approved it, but it's certainly not widespread. So as far as I know, the only documents that are still requiring wet signatures are our settlement documents. Everything else can be signed via an electronic signature. So in North Carolina, we are governed by the UETA, Uniform Electronic Transaction Act. The UETA is actually available in most states. Most states have their own UETA, which sounds to me like something you should be able to clear up with a hit of cranberry juice, right? Like a little azo. I'm gonna fix that UETA I got. It's been a real pain though. In fact, it just means that I can sign a document on the computer machine by making a mark or whatever as soon as they tell me that it is going to be binding. North Carolina has a UETA. South Carolina has a UETA. I bet California has a UETA. Each state has its own, and that governs contracts inside the state. If we're going to go across state lines or international, then we are governed by the E-Sign Act. So the E-Sign Act is the federal version of the UETA, except it's there to regulate our interstate or foreign commerce. Everybody good with that? Excellent. We're going to clear that up. We're going to clear that up for you. All righty. So we have spent all this time. We talked about how to do the offer and acceptance process and communication. We talked about what makes a contract. Now let's go kill it, shall we? Now we've spent all this time building this nice castle in the sand. Let's go smash it. How do we terminate a contract? Anybody want to give me an idea of different ways we can bring a contract to an end? We can agree to it. How else could we potentially end a contract? What's a good way to bring a contract to an end?
Sell it.
Sell it. Full performance, baby. That's right. Breached by a party. And then two that we don't often think of and often get confused, and that's why there won't be a test question on it. Impossibility of performance and operation of law. Either we agree to bring them to an end, we perform the contract, somebody breaches the contract, it becomes impossible to perform it, or there is something in the law that will cause our contract to discharge. Let's start with discharge by agreement. It is always possible that the parties will achieve accord and satisfaction, which is a mutually agreed upon compromise. Let's just cancel the contract. I'll give you your due diligence back. You walk away with the expenses, and we'll call it good. Accord and satisfaction. Release or notice of termination. That's a document to terminate the contract. Hopefully, we will do that following discharge by agreement. We will provide a release, the notice of termination signed by all parties. It's possible that instead of a discharge, instead of a release or a notice of termination, our mutual agreement will be to create a novation. Anybody see this movie? Oh, terrifying. If you haven't seen it, oh, it's a great movie. I used to stand, this is one of the reasons I didn't fit in at the real estate commission. I used to stand behind people in their cubicles with a pair of scissors going like this. And that just weirded them out. They'd never seen the movie either. A new contract, it's a previous contract. I fit in like a left shoe on the right foot. A new contract to replace a previous contract, sometimes with different parties. Guys, every time we break out a clean copy, novation, focus on new. Subsequent modifying agreements are agreements between the same parties to change the contract a little bit. You know, we're just going to give it a facelift. Okay, we're just going to do that very fashionable thing. We're going to do a little Botox. I personally have the subsequent modifying agreement of a filter on Zoom that keeps me beautified. You do not want to see this alpha Zoom, okay? Our subsequent modifying agreement here in North Carolina is, guess what it's called? Guess what it's called? It's early yet. We haven't talked about how well the forms are named. Hold on a minute. I'm going to look for it. It's called the agreement to amend the contract. This is our subsequent modifying agreement. We can leave the agreement we already have in place until everybody signs our subsequent modifying agreement. And that way, there is never a point where our contract stands in question. Full performance, baby. That's when we're selling a property. They hand over the keys. We hand over the money. We get paid. Yes. This is our favorite way to end, right? Sometimes we can't go out this way. And that's because we have breach. Breach is when a party, and I like to say it, breach. I can't help myself. Every time I hear it in my head, I go, breach, like a pig squealing. When a party in a transaction refuses, now you can too, refuses to consummate the contract, which means full performance, baby. It's just there's not enough use of the term consummate in the world, so I thought I'd break it out. Follow the terms of the agreement. People can breach if they don't adhere to the material terms and conditions. Not everything in a contract rises to the level of a material condition. But if it is a material condition and they won't honor it, that's breach. It doesn't matter if ultimately they're willing to sell it, if what they're willing to sell isn't what they promise. So just because they're willing to go to the closing table does not mean they are in honor of the contract. When we're doing resale, sellers have expectations, not even many, but a few. If they don't honor the terms and we go to close, we are accepting it regardless of the breach. So it is important to note that breach does not create a void contract. It creates a voidable contract. If we can still choose to go forward with it and close, we can do that, even if they're not honoring the material terms of the agreement. It's just important to note that if they do go forward and consummate the transaction, then their recourse to breach may be over if it's not surviving through the language of the agreement. Impossibility of performance means that we can't sell it because what we have to sell doesn't exist anymore. Okay? If you are trying to sell a house on a lot and the house burns down, then you can't sell the house on the lot. If we're in the offer stage, this will kill our listing agreement. If we are in the contract, it may kill the contract. But it is important to note that unless it truly is impossible to perform, they may be able to go forward with the contract if they choose. So if the house falls into the ground, they may say, I didn't want to buy a big hole in the ground. I want out of this contract. But if the house falls into the ground and they were like, I was getting ready to knock that house down and dig 18 feet into the ground, I can't wait. Thank you for saving me the money. I'll take this hole in the ground. They have every right to go forward with the contract. And in North Carolina, they get the settlement from the insurance too. The owner of an old warehouse contracts to convey it to a buyer. Between the signing of the contract and the closing date, the warehouse burns to the ground through no fault of either party. The destruction of the warehouse makes performance by the seller impossible. There's no longer a warehouse to convey. Although the performance of the contract in its original form by the seller is excused, the buyer may be primarily interested in the land and thus may still insist upon the transfer of the property as it is. This is where that risk of loss clause in our contracts addresses this concept and says to them they will get it and they'll get the insurance settlement too.